pious obligation is well understood. But there is no
Obligations,
such.
highest obligations are well understood.
Pious
Not-
obligations, yes. Yes, sir.
But husband's obligation for the crimes of a lady.
That means we'll hear this also.
So one of the pious obligation on the lighter side
Yes,
is not to shift a criminal liability on the wife.
to take on himself.
Yeah, yes, that is one of the pious, that is on the lighter side.
Yes, yes, sir.
Yes. Lord, my submissions are, my lord, in six compartments.
Yes, sir.
Lord, first, Lord, the arguments are advanced about the scope of the governor's power under section 17A,
Yes,
relying upon the parameters prescribed under section 19.
yes, sir.
Lord, I would wish to assist your lordships on the question that section 17A stage
Yes, sir.
and application of mind. Well, I'll take your lordships through, my lord. I'm just giving
Yes,
outline of what I'm respectfully assisting your lordship with.
yes,
What are the differences between the provisions of 17A and 19, and resultantly, what will be the parameters of governor's jurisdiction, governor's power, or governor's duty, whatever we may call it, while exercising powers under 17A or 19. Second, my respectful submission is that the parameters of the governor's jurisdiction under 17A would be akin to what is described by the Honorable Supreme Court in Lalita Kumari's case, that he has to see a prima facie case whether the facts emerges a cognizable offense or not. If the facts reflects commission of a cognizable offense, he is not a judge. He is not supposed to sit in appeal and decide whether offense is committed, not committed. He has to say that yes, as alleged, there is a cognizable offense, and he has to discharge his function under 17A. Third, the decision of the governor, because of two reasons, by the virtue of the office he holds, and he deals with, my lord, other constitutional functionaries generally, and considering the very nature and scope of section 17A, is such that his reasons, which are recorded in the order of approving 17A investigation, need not be elaborate. It must reflect application of mind nonetheless, because any elaborate reasonings will have a tendency of prejudicing the potential accused during the investigation as well as during the trial. But I must show, it's the duty of my lord the governor to show that there is an application of mind, and thereafter the reasons are recorded, and the reasons can be found from the file also. The next submission, my lord, which I am making, my lord, my learned friend's argument was that in case of one complainant, the governor issued notice. In two cases, the Honorable Governor did not issue notice. My lord, my respectful submission in law, and which I will substantiate by, my lord, the provisions as well as the legal interpretations given by the courts,
yes,
that at the stage of 17A, there is no requirement of any principles of natural justice.
yes,
He may have chosen to issue notice in one case, but non-issuance of notice, even in that one case, would not have created any prejudice to anyone, because in law, there is no contemplation of hearing. And I will elaborate, my lord.
at the stage of 17.
At the stage of 17A. Because Supreme Court has went to the extent of saying, even at the stage of 19, hearing is not required.
Yes,
Yes, because 19 is post-investigation.
yes,
Lord, next contention I would, my lord, assist your lordship with is why the governor was required to act in his own discretion and not, my lord, as per the aid and advice as, my lord, contended by the petitioner. Aid and advice of the Council of Ministers under Article 163 of the Constitution will have no application when the Honorable Chief Minister is facing an allegation. I'm saying only allegation.
Yes.
It is yet to be decided. And the governor is called upon to decide 17A. Lord, the submission, my lord, which my learned senior, my lord, just now made.
Yes.
Professor Ravi Kumar Verma, my lord, a very eminent counsel, my lord. I have an occasion to oppose him in one of the reservation matters before the constitutional bench. My lord, the submission is that mention of BNS vitiates the decision of the governor. My lord, that submission is required to be, my lord, only pointed out to be rejected for the simple reason that suppose IPC offenses are also mentioned. The governor will not go under 17A, which offenses are made out. Governor will only say that yes, prima facie, criminal offenses are made out, and it will be for the investigating officer to decide under what provisions charge sheet, if any, is to be filed. Because the investigation may result into filing of the charge sheet, it might result into filing of a closure report, but in the event of filing of a charge sheet, the investigating officer will take his own independent decision based on the material of the record that these are the provisions which are attracted, which, Lord, in a given case
Little
of
earlier also procedure, it is not yet referred even for investigation. So while referring, these crimes may be noted, may not be noted.
correct, my lord.
That's all.
And even if it is noted, IO will not be bound by them. Maybe the governor has missed 2-3 sections, hypothetically. The IO can still say that the honorable governor did not have full facts. The honorable governor was relying upon only a written complaint. Now I have investigated, I have documentary evidence, I have oral evidence, I have other evidence, and now I feel that 3 other sections are also required to be added. Then he would add it. So mention of BNS, IPC, or any of the sections or non-mention thereof would not vitiate the order, in any case will not cause any prejudice to the petitioner so as to give him an opportunity to challenge it on that ground. And last, my lord, which again, my lord, my learned senior friend, my lord, mentioned that the criminal liability of the husband, of the wife, cannot be attributed to the husband. Dr. Singhvi also made a submission that I have not made any recommendation. If that is so, then fine, then 17A is not required. The complainant can straightaway proceed with the criminal complaints. Then 17A goes, my lord, their problem is solved. They should withdraw the petition that I have not done anything in my official capacity. I have not recommended anything. I am not involved. Maybe my wife was beneficiary. All right, then 17A is not required. Then what are we arguing for? Why are we troubling your lordship with? By showing justification for validity of 17A order. Lord, it's a self-defeating, suicidal argument, in my respectful submission. Now, my lords, my lord, I have prepared a summary of my submissions, my lord.
Yes, sir.
And so far as governor's application of mind is concerned, Lord, I have gone through the file. I will share the file with your lordships.
Yes.
And without making it a precedent, I
Yes.
will share with the other side also.
Yes.
Though, my lord, in law, my submission
Okay.
is that the potential accused cannot have an access to
Yes.
that file, but we don't wish, my lord, anything to play hide and seek. My lord, I'll show it to the petitioner also that this is the application of mind. And based upon the considerations which are reflected from the file, the governor has reached the conclusion that this is a case for 17A and he has passed the order. My lord, these are my written submissions. I'll give it.
Yes, sir.
Lord, page 5, your lordship may directly come to page 5. Up to 4, my lord, I have only pointed out. This is the skeleton on which, my lord, I'll address your lordships.
Yes.
Lord, 26th of July 24, a show cause notice dated 26th July 24, which is placed by, my lord, the petitioner at annexure C, was issued to the petitioner in relation to the petition seeking grant of approval for investigation on the basis of complaint filed by respondent number 3. My lord, it is an admitted position that what is the content of the show cause notice is only the complaint of respondent number 3 and not the other 2 complaints. Because my submission is going to be even this step was not necessary. Therefore, non-compliance with other 2 makes no difference, creates no prejudice, gives no cause of action. Then, my lord, on 31st of July 24, a cabinet note was put up for consideration of the Council of Ministers in relation to the show cause notice issued by the Honorable Governor of Karnataka to the Honorable Chief Minister to respond within 7 days as to why sanction for prosecution should not be granted, as requested by one Sri T.J. Abraham in his application dated 26 July 24. The cabinet note in its introductory paragraph notes as under. Lord, please read. The Chief Minister, with his note dated 27th July 24, the next day of receipt of notice, has directed the Chief Secretary to place the matter of a show cause notice issued by the Honorable Governor of Karnataka, addressed to the Chief Minister of Karnataka, video number so-and-so, before the cabinet, along with all the materials available on record with the Urban Development Department and after consulting with the Learned Advocate General. Accordingly, the Chief Secretary, after obtaining the Advocate General, it should be the opinion of the Advocate General, but the mistake is in the original note, my lord, it's not in this.
Yes.
Accordingly, Chief Secretary, after obtaining the opinion of the Learned Advocate General and examining the records, directed the Urban Development Department to put up a cabinet note with details along with the opinion of the Advocate General on the matter for consideration of the cabinet. My lord, here, on a lighter note, my lord, nowhere the government writes Learned Advocate General. My lord, that is the practice throughout. I'm not criticizing. I'm saying on a lighter note, because my lord, there was, my lord, an eminent lawyer called F.E. Smith. Yes. He had said 3 things. That in the court of law, never believe 3 things. When the honorable judge says, my learned brother, he neither means that he is learned, nor he treats him as a brother. Second, when I say, my learned friend, we are generally friends, but we rarely treat each other as learned. And, my lord, and when we say that with profound respect, Lord, with profound respect generally mean, as per him, Lord, this is not my interpretation, that your lordships have not understood, but let me make your lordship understand. And Lord, he has elaborately detailed that Lord, with respect means you have not understood. Lord, with profound respect means you have completely not understood.
Not at all understood.
Not at all understood. So these are the jargons. So we call each other learned. And that is the irony. My lord, when your lordship set aside the order of the trial court, your lordship would say the learned judge has not understood even basic fundamentals of law. My lord, if the second part is true, then how is he a learned judge? But this is, my lord, what we live with, my lord, since centuries. Then the cabinet note dated 31st of July at annexure D from page 267 of the writ petition filed by the petitioner. Then Council of Ministers, through its cabinet decision, advised the Honorable Governor to withdraw the notice dated so-and-so issued by him to the Honorable Chief Minister based on the petition and addendum dated so-and-so filed by one T.J. Abraham, and to proceed forthwith to reject the said application by denying prior approval and sanction as requested by the petitioner Abraham. The decision of the cabinet is, my lord, also placed by them.
Yes.
The petitioner submitted his reply to the show cause notice dated 26 July 24, which is also annexed, and something very interesting from the note prepared by the Chief Secretary. Thereafter, the Learned Advocate General. Thereafter, the matter comes to the cabinet. Thereafter, the Honorable Chief Minister prepares his reply, etc., which I'll come, my lord, when I deal with that. Respondent number 2 placed the file in relation to the issue at hand, along with the decision of the cabinet dated so-and-so and reply of the petitioner dated so-and-so before the Honorable Governor. The respondent number 2 is the Secretary to the Honorable Governor, Lord, whom I represent, and he placed that these are the papers. This is the note of cabinet. The cabinet has to say this, and all documents, as I will show from the file, complaints, documentary evidence is annexed with the complaint, etc., my lord. The opinion of the Learned Advocate General, everything was placed. Then, 8/8/24, the Honorable Governor directed respondent number 2 to put up the file along with comparative statements of the petitioners. Petition, my lord, he understands, my lord, to be complaints.
Oh, this was done.
Yes, my lord. Well, there is an elaborate application of mine. I'll show from the file. I'll share it with my learned friend. The Honorable Governor directed respondent number 2, that is his principal
Yes.
secretary, to put up the file along with comparative statements of the petitions received in relation to the grant of sanction, reply of the Chief Minister, and the decision of the cabinet. That you give me in this format, then I'll make up my mind. Then 14th August, comparative statements as referred above were placed before the Honorable Governor for his perusal. 14th August 24, after perusing the file and discussing the issues, the Honorable Governor directed to resubmit the file along with notes or analysis points as dictated. The learned governor dictates that this is the allegation of the complainant. This is what the cabinet note says. This is what the reply of the Honorable Chief Minister says. And this is the note. The note is dictated by him. I'll place it. It's a big chart, my lord. Several charts were prepared and the Honorable Governor, my lord, himself dictates. Based on, and this comes, my lord, in the noting file also. It's not that I'm saying for the first time that it was dictated by the governor. In the noting file, my lord, it comes that it was dictated by the governor. Based on the comparative statement and available documents and petitions. The file along with all the above referred documents and comparative statements as dictated by the Honorable Governor was placed before the Honorable Governor for necessary orders. The order of approval for investigation was passed by the Honorable Governor and, my lord, thereafter, my lord, the petitioner is before your lordships. Now, my lord, taking the first point first. Lord, your lordships are aware, prior to, my lord, the enactment of the new Prevention of Corruption Act,
Yes.
the amendment to the Prevention of Corruption Act, my lord, which was in
26/7/2018.
yes, my lord, 18. There was no concept of an approval prior to
Yes.
the investigation. The only concept was pre-cognizance sanction
Sanction.
under section 19. My lord, for the first time, 17A comes. My lord, your lordships have read and reread this provision, but only read kindly, my lord, on my request,
Yes.
page 8, page 8, only subsection 1.
Yes, sir.
No police officer shall conduct any inquiry or investigation into any offense alleged to have been committed by a public servant under this act. It doesn't talk of BNS or IPC. Under this act, where the alleged offense is relatable to any recommendation made or decision taken by such public servant in discharge of his official functions or duties without the previous sanction of ABCD. My lord, according to me, this case would fall within B and C, but I'll have to independently substantiate that it is the governor in case of the Honorable Chief Minister who is not supposed to act as per the aid and advice of the Council of Ministers. Now, my lord, so far as this is concerned, my lord, I have already pointed out that the scope is very, very limited. I have to, as a governor, see whether the complaint and the documents which are placed makes out a cognizable offense which requires investigation. It may result in a charge sheet or the report under 173 as we call it, or a closure report as per old section 169. But that's not the call the governor is permitted also to take. The governor cannot say that I have examined and cognizable offense is made out. It's of a serious nature. It will be attracting this provision. It will be attracting so much punishment, etc., etc. No, he will go by prima facie case that whether it needs to be examined by an investigating agency as an investigation under the provisions of law. Lord, your lordships have had an occasion to consider, my lord, this honorable court had considered, your lordships, my lord, thereafter, my lord, gave a detailed
Yes.
and illuminating decision. But Sri Rupa,
Yes.
my lord, I would your lordships like me to, my lord, place for your lordship's
Yes,
consideration.
two very different concepts.
Yes, my lord.
Approval and sanction, they stand on
They
different.
they stand on different footing. The parameters are different, the considerations are different, the way in which you deal with the application is also different.
In that case, there was nothing said.
Yes.
Nothing said except saying we grant approval.
Approval.
There was no application of mind at all in that case.
Yes.
That's why that was.
And my lord, they are relying upon these judgments to show that there has to be an application of mind. My lord, in my respectful submission, to canvass a proposition that any administrative order has to be after application of mind, you don't need any judgment.
It's rudimentary.
It's elementary, my lord. It has to be after application of mind. You don't need any judgment. There are certain, my lord, universal propositions which doesn't need to be supported by any judgment. I'm straightway conceding it has to be after application of mind. It will depend upon facts of each case. And what is the extent of application of mind
That
is
Case to
relevant.
case basis.
Is based on facts to facts.
Facts.
So, my lord, I'm placing it, my lord, but I'm not reading, my lord, this judgment. Lord, kindly see what would be the scope of the power, my lord, because your lordships would be laying down the law in while deciding this. Not only with reference to a scenario where the honorable governor, who is a constitutional functionary, is deciding the approval issue of the honorable chief minister, who is also a constitutional functionary. 17A applies across board.
Yes.
In case of a tehsildar or a patwari, maybe the tehsildar is or deputy collector is the authority under 17A.
17A.
So what is the scope of his inquiry? What is the scope of his application of mind? Whether to exercise 17A power as requested by the complainant or not to exercise. Lord, that broadly, in my respectful submission, we can get assistance, my lord, from Lalita Kumari judges.
Yes.
That your lordship would find at page 12. My lord, I can take your tell your lordship, my lord, whatever paragraphs I have quoted,
It's quoted.
I have, my lord, the full text of the judgment, which
Yes.
I'll place.
Yes.
But this is only for ready reference.
Yes.
I'll place, my lord, the entire bunch, my lord, for your lordship's consideration.
Yes.
Right now, my lord, I'm not giving.
Yes.
My lord, please come, my lord. This is a your lordships are aware it's a constitution
Yes.
bench. 5 honorable judges, my lord. 31.
Yes.
And I'll skip some of the paras, my lord. The FIR is a pertinent document in the criminal law procedure of our country, and its main object from the point of view of the informant is to set the criminal law in motion, and from the point of view of the investigating authorities is to obtain information about the alleged criminal activity so as to be able to take suitable steps to trace and to bring to book the guilty. Now, kindly come to page 30, para 49. I'll skipping, my lord, other paragraphs.
Yes, sir.
49, highlighted bold part. Consequently, the condition that is sine qua non for recording an FIR under section 154 of the code is that there must be information, and that information must disclose a cognizable offense. This applies squarely to 17A. If any information disclosing a cognizable offense is led before an officer in charge of the police station, someone has forgotten, my lord.
These things happen.
Yeah, these are, my lord, some interesting incidents in the virtual hearing.
They are the
Must disclose a cognizable offense. If any information disclosing a cognizable offense is led before an officer in charge of the police station satisfying the requirement of section 154(1), the said police officer has no other option except to enter the substance thereof in the prescribed format, that is to say, to register a case on the basis of such information. Lord, I'm not comparing the police officer with the governor, but I'm saying police officers' function under 154 is the function of any approving authority under section 17A. He may be a tehsildar or he may be the honorable governor. That whether prima facie offense is made out, then not only is duty bound, it is not only his right, he is duty bound to accord approval. The provision of 154 of the code is mandatory, and the officer concerned is duty bound to register the case on the basis of information disclosing a cognizable offense. Thus, the plain words of section 154(1) of the code have to be given their literal meaning. The use of the word shall in 154 of the code clearly shows the legislative intent that it is mandatory to register an FIR if the information given to the police discloses the commission of a cognizable offense. Therefore, the context in which the word shall appears in section 154(1), the object for which it has been used, and the consequences that will follow from the infringement of direction to register FIRs, all these factors clearly show that the word shall used in 154(1) needs to be given its ordinary meaning, etc., my lords. My lord, my learned friend may be tempted to say that in case of 70